Good evening, everyone. Welcome to this live session and welcome to Live Law Academy. In this session, we are going to discuss a very important question. Can secretly recorded conversations between a husband and a wife can be given in the court as evidence? Now, this question interacts with other areas of law. It interacts with law of evidence. It interacts with right to privacy and the overall situation in matrimonial litigation. Whether such recorded conversations violate right to privacy of a partner, whether such conversations qualify to be privileged communications between husband and wife under Section 122 of the Indian Evidence Act. These questions are addressed by the Supreme Court in the recent case of Vibhor Garg versus Neha. Let's understand the facts of this case first. The couple got married in the year 2009 and they were blessed with a daughter in 2011. But in 2017, husband filed a petition for divorce under Section 13 of the Hindu Marriage Act. He then, when the matter was at the evidence stage, he filed an affidavit in lieu of his examination in chief. And later, he moved an application to permit him to submit a supplementary affidavit. Now, what did this supplementary affidavit contain? It was accompanied with memory card, CD, and transcript of secretly recorded conversations between him and his wife. The wife objected on the ground that it results in violation of her right to privacy. But the family court, the matter was before the family court in Batinda, which is in Punjab. The family court allowed his application. The wife then moved the High Court against this order, and the High Court ruled in her favor. And against that order, now the husband was before the Supreme Court. The Supreme Court broke down the issue into three main questions. First, whether such conversations can be rendered in evidence at all. Second, whether Section 122, which deals with privileged communications between husband and wife, prevents such recorded conversations to be given in evidence. And lastly, can such evidence be rejected merely on the ground that it violates right to privacy, merely on the ground of privacy? Now, for first question, the Supreme Court noted that this is nothing new. This question was already dealt by the Supreme Court itself in number of previous decisions. And in this case, those decisions were mentioned in the judgment. One such case on which the Supreme Court relied is Yusuf Ali versus State of Maharashtra. You can also note down the citation. Yusuf Ali versus State of Maharashtra, AIR 1968 Supreme Court 147. In this case, the accused was recorded secretly by the police. This was a corruption case. His conversation was recorded secretly by the police, and the tape, it was objected by the accused that should not be admissible before the court of law because he was not knowing that he was being recorded. The Supreme Court rejected his argument. The Supreme Court held that if such conversation is shown to be relevant to the case, and the authenticity of the recordings are established, then such tape recordings can be admissible under the Indian Evidence Act. So it does not matter that things are happening without your consent. What matters is whether it is relevant as a piece of evidence under the Act and whether its authenticity has been established. Right? Now for second question, that is on section 122 of Indian Evidence Act. Let's refer to the text of 122 and analyze it. Let's do that together. I have already highlighted some this section 122 in such a way that it becomes very easy for us to understand. Right? See, it says communications during marriage. No person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married. Now, this is the first part of section 122. Section 122 has two distinct parts, and these two distinct parts are separated by this semicolon, which I have highlighted by red. First part is before this, second part is after this. Now, the first part, the part that I just read, it lays down the rule of compellability. It bars the court from compelling anyone to give evidence of the communication that happened with his or her spouse. This is the rule of compellability. Now, the second part of section 122, let's read it. It lays down the rule of permissibility. Let's read. Nor shall he be permitted to disclose any such communication unless the person who made it or his representative in interest consents. Right? So, even out of own volition, the person, the spouse, cannot disclose the communication that happened unless the person, the spouse who made the communication, gives his consent or his representative in interest gives such consent. But to this rule of permissibility, we have exceptions. Second part of section 122 carries exceptions. Let's read that part also. Except in suits between married persons or proceedings in which one married person is prosecuted for any crime committed by the other. So this latter part of 122 is not applicable to the proceedings in which the husband and wife themselves are parties, right? Which happened in our case. Apply this latter part of section 122 to the facts of this case. It was a proceeding under section 13 between the husband and wife. So the communication which otherwise would have been hit by 122 in this situation can be given in evidence by way of an exception, which is clearly mentioned in the second part of section 122, which deals with the rule of permissibility. Now that the section 122 is out of the way, the only question which requires our consideration and which required the consideration of the court as well was regarding the right to privacy. You see, the court in clear terms held that privacy cannot trump justice. You cannot take refuge under right to privacy, though right to privacy is of utmost importance. It is one of the vital constitutional values, right? But it cannot be used. You cannot take refuge under right to privacy and claim that there is a blanket bar on the admissibility of certain facts. Right to privacy cannot overshadow court's duty to consider relevant evidence in cases. In the later part of the judgment, 3 to 4 paragraphs are dedicated on this discussion, I advise you to go through that part of the judgment at least. It's an interesting discussion. Many things around the fundamental rights, particularly right to privacy, will be clear. And at Live Law Academy, we always, though we discuss the judgments and the concepts at length, we always advise the participants and the students to go through the real text, the true text of the judgment, because nothing can bring more clarity than that, right? So the Supreme Court in this case restored the order of the family court by which the husband was permitted to give memory card, CD, and transcript of the conversation secretly recorded by him, right? So this was on the issue whether secretly recorded conversations between husband and wife can be given in evidence. Yes, in matrimonial cases, it can be done. And if you find value in these sessions, then please comment, like, share, and subscribe. And I will see you in more such sessions with more such judgments, which make you read the judgment, which make you think deeper in law, right? Thank you for joining me today. And in case if you have any doubt, any comment, then please, you're most welcome to mention that in the comment section. And Live Law Academy has come up with a short course on minor criminal laws where the acts like Sexual Harassment Act, POXO, Juvenile Justice Act, Probation of Offenders Act, all these statutes will be covered, and you will be taught by none other than Justice K. Abraham Matthew, who was a judge at Kerala High Court, and after that he was also uh, working with the Kerala Judicial Academy. So he has seen the practical side of the law, which is usually missing when you read these acts on your own from the books or directly from the statute. So do check that out on the website, and feel free to contact us if you have any doubt. Thank you, thank you, thank you, thank you very much for the positive comments in the comment section. Thank you very much for joining me today, and we will meet again with some interesting discussions on the recent legal developments. Thank you so much.